Good afternoon, everyone, and welcome to the Alternative Dispute Resolution Certification Working Group. And as you just heard, the meeting is being recorded. Angela, would you please call the roll?
Armstrong, Coulter,
Present.
Curtis,
Here.
Dinkin, Dubo, Ellis,
Here.
Dr. Getz, Higuchi,
Here.
Hodgson,
Here.
Jones, Kelly,
Here.
Opakin,
Here, my audio is by phone, so I hope you can hear me.
thank you. Cruz, Lowe,
Here.
Lucky,
Here.
Polewski,
Here.
Judge Pichon,
Here.
Robertson,
Present.
Tuckman,
Here.
Welch,
Here.
Yamshan.
Here.
You have a quorum.
Thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Angela, would you please provide the instructions?
For those participating by Zoom video, you should have a function for virtually raising your hand, the hand icon at the bottom center of your screen. Please click on that hand icon if you'd like to give a public comment, and you will be called in order. For those participating by phone, you can virtually raise your hand by pressing the star key and then the number 9. Each speaker will have 3 minutes, and you'll be verbally alerted once you have 30 seconds remaining. So if you'd like to give a public comment, please use the raise hand function at this time. Judge Pichon, I
Angela,
don't see any raised hands.
Oh, okay. Thank you very much. Next, we would normally have the approval of the minutes, but we won't have any approval of the January 12th minutes from the last meeting. And I'm going to ask Mia or Ms. Ellis, would you please explain the reasons for this? And also the reasons that item 2.3, the report and possible action on application of State Bar Certification Program and complaint procedure to court programs appears on the agenda, but it is not an action or discussion item.
Yes, thank you, Judge Pichon. As the members know, the agendas have to be posted at least 10 days before the meetings. There were less than 10 days between our two January meetings, our last one being January 12th. You may also have noticed that there was, after the last meeting, a notice of adjournment. So we adjourned the January 12th meeting to this meeting today. So we are continuing under the same agenda. So the meetings minutes for the January 12th meeting, as well as today's meeting minutes, will be posted and for approval at the February 10th meeting. So although the item 2.3 continues to appear on the agenda, as you also all know, we addressed that issue at the last meeting. So that is, there's no item to discuss related to that. Thank you.
Thank you, Ms. Ellis. So there will be no approval of the January 12th, 2026 open session minutes. They will be approved on February the 10th, 2026, which is our next meeting. All right, next on the agenda is my chair's report. And as I've just said, there's one more meeting, February 10th, and our goal today is to post our recommendations for public comment. While I don't have a report for today, I did want to just say just a couple of words. And I've said this before, that the working group members were very carefully selected for your expertise, your skill, your knowledge, and your experience. That's why it's so important to listen to your points of view regarding the topics that have been given to us to consider. So, getting your input has been of utmost importance to me. And as chair, I have endeavored to make sure that your opinions, concerns, and feelings about the issues be heard. So today we're going to return to the tiers subgroup to complete their presentation. Please remember we've returned matters to them twice and this is the third time that they have reported. We have also put the provider organization subgroup off for 2 meetings. Our goal now is to make our decisions so that we can hear from other interested parties. So I'm apologizing ahead of time because I will be watching our time very closely. And if I might ask you while you're speaking if you could, wind it up, and I'm sorry to do that. But we have to get through with the time constraints that we have. The public comment is very important to us, just in case there's something that we might have thought of. And please remember, after we get the public comments, they will come back to us and we'll have a chance to consider them and to provide our input again. So with that, I'm going to see if there is a staff report.
Thank you, Judge Pichon. I just wanted to follow up your comments just to also let the working group members know what the plan is after the post for public comment. We anticipate, as Judge Pichon said, we have our February 10th meeting. It's anticipated to be our last working group meetings before we go out for informal public comment. Will post the recommendations for 60 days. So that should get us through March and April, and possibly likely return to the full working group again to review and consider the public comment period, or excuse me, the public comment. So I anticipate probably sending out availability polls for May meetings and possibly 1 to 2 meetings in May. So that's right now what the schedule is, and if there are any changes to it, we'll keep you updated.
Okay, thank you. Thank you, Ms. Mia Ellis. So now we'll move on to item 2.1, and that's the report and possible action on the tiers subgroup recommendation. And I'm going to turn the matter over to Dr. Jack Getz.
Judge Prashan. Well, I don't know if I should be embarrassed or whatever, but I have benefited personally from all of the comments that have been made. This is the third time we're coming back on numbers 19 and number 20. So we'll spend some time reacquainting you with that. But I think the subgroup had took all your comments under great advisement and have tried to revise those 2 matters to reflect sort of what we thought is the consensus of the working group. Not to preset a vote or anything, but we were just trying to accommodate all the viewpoints that we heard. I will first, as we proceed, and again, I remind you that Judge Prashan has reminded us that this is the third time through. So when we get to the comments section, if you have something that you think has not been brought up before, we very much appreciate hearing it, as always. But I think everybody's pretty well versed on most of the comments that we've had to date. But first, I think, Mr. Weiner, you've prepared a document that shows at least some of the comments that we got at the last working group discussion and the motions as they are now formulated. And then after Mr. Weiner gets done, I'll turn it over to the Honorable Jackson Lucky, who wants to put those motions up for a vote. So Mr. Weiner, if you could go through some, thank you.
Sure. Thank you, Dr. Getz. This document just shows the versions of criteria number 19 and criteria number 20 that were presented to the working group as as subgroup recommendations during the January 12th meeting. As Judge Pichon has mentioned, that was the second time that this was back to the working group for comment. I've also, just for comparison, so in the top box of 19 and 20, there are a couple of things that are in capital letters and highlighted, and these are notes that I made during the January 12th meeting to reflect comments that some of you had raised during the group. These comments went back to the subgroup, and the subgroup met for another 90 minutes and talked just about these 2 items. They're now proposing the version down below that's in blue. And I've highlighted a couple of words here just to show that we've addressed. So during the January 12th meeting, there was an important clarification that the limitation on accepting new matters should only be during the pendency of the initial matter. So that's been incorporated here in number 19. And there was another important qualification that the limitation on accepting new matters should be not accepting new matters without the consent of the parties. And also, there was a comment that that should be before the practitioner takes the first case, so that there's not an awkwardness, if you will, of a party saying, no, I object to you taking new cases. So those have been reflected down here. Again, during the pendency of an arbitration or mediation, the practitioner declines to enter new professional relationship with the party or lawyer in the pending matter unless, before the selection or appointment in the pending matter, all parties and lawyers agreed the practitioner may enter new professional relationships while the matter is pending. Dr. Getz, would you like me to stop here, or would you like me to talk about the revisions that were made to number 20 as well?
Please address number 20, please.
Sure. Yeah. So in number 20, this was a requirement that the practitioner notify the parties and lawyers in an ongoing matter if they receive an offer or request to enter a professional relationship. This closely tracks one of the arbitrator's obligations in consumer arbitrations, and one of the concerns or comments that was raised had to do with timing. When should the arbitrator or practitioner give this notice? And there were two suggestions that were made. One was as soon as practical, and the other was no later than 5 days. The reason for the no later than 5 days is that that's the requirement in the Judicial Council arbitrator ethics standards. One of the comments, additionally, at the last meeting was, I believe Ms. Cruz raised this comment, that we shouldn't raise an inconsistency by having different time requirements. And so, after considering those comments, when the subgroup met on the 16th, they decided to recommend that the notification should occur within 5 days of receiving or accepting the offer, as is required in consumer arbitrations.
Thank you, Mr. Weiner. As I mentioned, we went back in the subgroup. We spent a lot of time going through these and taking into account the comments from the working group. There was a general consensus in the subgroup that we feel we really believe in these two matters. And the Honorable Jackson Lucky offered to put these up for a vote and discuss, at least briefly, why he believes that these are strong recommendations and should be followed. Judge Lucky.
Thank you, Dr. Getz, and thank you for your leadership. This has been a long road, and I think one of the questions that people might have is, we sent this back to you 9 days ago, and there aren't a lot of big changes, and there was a lot of discussion last time. And I think that what I'm going to say is that we have an uneasy consensus in our subgroup. I don't know that everybody is necessarily happy with the wording of this, but I think that where we all agreed was there was nothing we could do to mitigate the issues or the conflicts that we had within the subgroup, or some of the concerns that folks had when we discussed it in open group. And we thought really the best thing is to send this out for public comment. Maybe the comment of hundreds or thousands of readers, and I'm not saying that we would get hundreds or thousands of comments, but the comments that arise from a couple of hundred or a couple of thousand extra sets of eyes and the brains that come behind those eyes might give us some better insight as to how we could come up with a rule that was more palatable to a larger group of people. But I think that we all agree that this is about the best that we could do in addressing the concerns that everybody had. And we felt that if we put it out for public comment, which is, I just want to remind everybody through this process, the end result is that this is not what the state bar is going to adopt, but it's going to be what we put out for public comment so that we can learn better what the public wants from us, or what other practitioners or what other consumer attorneys want from us. So it's our very strong recommendation, I believe, generally as a subgroup, with some dissension here and there on particular points, that we put this out for public comment and that we approve it as currently written. And so with that very long preamble, I will move to approve both proposals 19 and 20 as currently written.
I'll second the motion. Ms. Kelly?
I'll take the vote.
There's
I
a,
see Mr. Palevsky's hand.
yes.
And I realize that sometimes it's difficult for the chairs or people
Yeah.
leading the discussion to see the hands. So when I see them, I will call them out if that's helpful.
Thank you. Mr. Plevsky.
Well, I said this before we started. I am very grateful to the committee for taking this back and doing this. And I will support these going out for public comment. I think that it goes a long way to addressing the bigger picture. I think there may be ways to tweak it, but I really do think this is a decent approach because it gives the power back to the consumer or the parties themselves. The only questions I had, and I don't know if you thought this through, or maybe the folks from the providers can help explain how the consent would be obtained. Is it in the filing document or the answer document, if it's coming before the selection? And then how do the lists get put together? Meaning if the parties don't both consent, what do the providers do in trying to compile the appropriate list for that case? But with those questions that someone's going to have to figure out, I'm very grateful, and I think this is a good approach. Not the best, but yeah.
Judge Lucky.
Thanks. That's a great question, Cliff, and it is something that we discussed. I'll let somebody who maybe Daniel or somebody talk about something from a smaller organization or from an individual. But the way that a lot of providers do this is, we have disclosures that we put out, as you've pointed out, Cliff, that will say, I agree, I will take business from the parties or the clients during the pendency of this. And so what I think one solution, I'm not saying this would be the solution, but one of the solutions I envisioned is that along with our disclosures, instead of having it as it's currently written, is that when the disclosures went out, it would say, I agree that I will not take. The other thing is that in terms of the striking and ranking process, and this is something that I think that individuals could do as well as providers, but there would be a place on a website or somewhere else where people could see, is this person somebody who declines, or is this somebody who is a tier 3 certified arbitrator? And if somebody is listed as a tier 3 certified arbitrator, then you know from the get whether they are someone who follows this rule, because you cannot become a tier 3 arbitrator without adopting both 19 and 20. On the other hand, if somebody was using it as a tier 2 or was a tier 2, then I would think that there would be a place where parties could look that up before striking and ranking or before appointing somebody to figure that out before they chose an arbitrator.
So you would be putting people on the list who, even without consent having been obtained, if the parties say no, you'll still put people on the list who say they will not take that case, is the
You know,
concept?
I don't want to speak for providers and how they would do that. I want to make sure that I stay in my lane as far as making proclamations. We discussed as a group how providers or individuals might do this, but because we do have a provider group that is going to be in a better position to talk about the mechanics or the processes by which this would happen, I would say that we talked about it generally that there would be that information available before the strike and rank process. Don't know how that would necessarily play out in terms of whatever contractual obligations the providers might have.
Last thing, and then I'll shut up. Just let me two things. I think it's really important that we stress that even if you agree and notify people that you will take additional cases, that there is a continuing, ongoing obligation to not do things that would create a reasonable doubt about your overall obligation to avoid the appearance of a conflict. One case in and of itself may not be enough, but there is that ongoing obligation that transcends it all in the present state of the law and otherwise. And then on our group, at the provider group, we're going to have to figure out what happens if there's only one person or two people who will take these cases. And you need a list of 7 or 10.
And again,
Mr.
I don't want
Wiener's
to.
been waiting. Can I get Mr. Wiener to comment first before
Sure.
we get into fact? Yeah.
Yes, I want to address Mr. Polewski's question and comment about how this is implemented, and just to note that there are a number of questions, sort of mechanical and implementation questions about how this is going to be done, and it will vary from provider organization to provider organization and from practitioner to practitioner, and the information that will go on the State Bar's website is yet to be determined. So this isn't the end of the discussion. It may be the end of the discussion, hopefully, of this working group at this time. I also want to point out that when the arbitrator ethics standards were adopted by the Judicial Council in 2001, there were monumentous obligations that were imposed, and people, provider organizations, how are we going to do this? And it was figured out, it was worked out. And compared to that, this is a pretty small detail, I think. So I have confidence that it will also be worked out.
Thank you. Ms. Curtis?
Yeah, so I just wanted to address Cliff's point toward the end of his presentation about concerns that arbitrators and mediators know that there's an ongoing obligation to maintain to protect the impression of impartiality. And I think number 20 addresses your concern, Cliff, but I want to know if not, because it does require a practitioner to agree to notify the parties of any offers. So if they get 1 or 20, they're obligated under number 20, and that's required of all tiers to inform the parties and the lawyers. But I just want to see what your thoughts are about that.
Well, yeah, I think the rule as it exists now, the amendments in 2016, say if you give notice that you will accept cases, you can take a case. Taking a case in and of itself is not evidence of corruption or misconduct. So taking a case, I would agree, if you give consent, is not evidence because you've got consent. I do think there's a difference between taking one case and taking 8 or 30 or 40. I don't know where that line should be drawn, but I don't think anything we're doing here should be read to undermine the obligation that's in the California Arbitration Act to adhere to the standards of 170.1, which includes that. And I think it's important to not think it's a license to take 40 cases just because you're telling somebody I just took 40 cases. That doesn't eliminate the concern. But I think if everyone's a grown-up about it and recognizes that there is a reasonable limit, I think that it's probably workable.
Wiener?
Yeah, I just want to underscore what Mr. Polewski just said, really an answer to his own question. Nothing in this tiers structure undermines or takes away or detracts from any of the ethical obligations that already exist. So it's not to say, it's not to give a greater license to do things that would be prohibited under the standards. And I think you recognize that in your last couple sentences.
Mr. Yamshan.
Thank you. One of the problems with trying to come up with one size fits all standards is one size doesn't always fit all. There are areas of arbitration where there are numerous cases and a small number of arbitrators available, and counsel sees the same arbitrators all the time, and they have the same opposing counsel all the time. And the arbitrators always make their disclosures because it's expected of them. And there's just no way around that. Now, these are very different kinds of arbitrations than consumer arbitrations. Oftentimes they will last a year and a half. Paul DeBow has some arbitrations that last 5 years and is in a similar situation of being in a niche area. So in terms of the working group, the tiers group, subgroup, we have tried the best we can to come up with some kind of universal application that would allow all the arbitrators to operate ethically within the rules and within the statutes. And a lot of the providers also have very stringent disclosure rules which arbitrators must follow. So I don't know if that will let you sleep at night, but those are the kinds of considerations that the subgroup had to wrestle with.
Thank you. Mr. Tuckman.
Thank you. I'll be brief. I will vote in support of the motion. It doesn't mean I necessarily agree with the proposals as drafted, but I do think that there's been tremendous discussion on these, and they're appropriate to be sent out for comment in this form. But I do have a clarification, which I also hope will be brief. But in 19, there's a lot of specificity about who's getting these communications. It's both the parties and lawyers in the pending matter and in the new matter. And in 20, it just talks about the parties. It doesn't refer to the new case or prior cases. I'm assuming it's everybody, but if that's a clarification that is easy to give, I would appreciate hearing it.
Mr. Weiner.
So Mr. Tuckman's concern might be addressed by revising the first line of 20 to say practitioner agrees to notify the parties and lawyers, or all parties and lawyers would copy the language from 19. I don't know whether that would be considered a friendly amendment or.
Judge Lucky, is that a friendly amendment to you?
I will accept the friendly amendment and amend my motion to approve accordingly.
Second accepts it as well.
All right. Well, thank you all for great discussion. So as amended, I think we should move forward on calling for the vote. Unless there's anything further, I think we've certainly spent a lot of time on this, and I appreciate all that time, and it's really made it better each time, including in the last 5 minutes.
I'll go ahead and take the vote. Armstrong, Coulter,
Yes.
Curtis,
Yes.
Dinkin, Dubow, Ellis,
Abstain.
Dr. Getz,
Yes.
Higuchi,
Abstain.
Hodgson,
Yes.
Jones, Kelly,
Yes.
Opakin,
Yes.
Cruz, Lowe,
Abstain.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Fishan.
Yes.
The motion carries.
All right.
Judge Prashant, I think that concludes our business from the tiers subgroup, and thank you so much. And Ms. Ellis as well for giving us all this time. Appreciate it.
Dr. Getz, yes, congratulations. I see a hand, Mr. Kelly.
Am I misunderstanding something? I think that what I saw on what I was sent was that 21 was completely stricken. Am I reading that correctly?
Yes, if I may, that was voted down at a previous meeting. I'm not sure whether that was on January 12th. I think it may have been on December 15th.
Well, so our Rule 3B that we already adopted says that every complaint committee and certified mediator, provider, and practitioner must make the complaint coordinator's identity, contact information, and function readily accessible to the public. And 21 seems to strike out that requirement entirely. I don't understand why that would be stricken entirely. I thought it was to be revised or something by the subgroup.
Yeah, I don't think that the tiers requirement that the vote not to adopt the requirement, the tiers requirement for 21, I don't think that alters anything that is stated in the complaint procedure that was previously approved by the working group for comment.
Okay, thank you for that clarification.
All right, thank you. Dr. Getz, thank you so much. I know that was a lot of work, 3 times, but that means that everything that everyone said was truly considered, and hopefully the public will agree with us that the product is great. But like you said, and Judge Lucky said, when the public reviews, someone may come up with something that we just never considered. But I have to congratulate you and your committee for a job well done. Thank you so much. So now we will move on to item 2.2, and that is report and possible action on provider organizations, subgroup recommendations, and that is to be presented by Ms. Jenna Ellis.
Thanks so much, Judge Pichon and Dr. Getz and the Tiers subgroup. Congratulations on completing your daunting task. Folks, we have a lot of things that have been presented to you today. And so I have some thoughts on how to proceed forward, but I'm going to welcome questions and input as we go along. Where I'd like to start today is with something that we've presented to you in the past, which is the recommendations for tiers relating to provider organizations. You might recall that at a prior meeting, we did vote on 4 of those that were presented, numbers 1, 2, 3, and 14, and those were agreed by the working group to go out for public comment. We have 15 total, minus those 4, to talk about today. You've seen 14 of them before. The 15th is new. And it's in response to comments and communications that we had during our last full working group meeting about incentivizing provider organizations to consider keeping a library of recorded MCLE content available. That's number 15. You might also see that in response to other comments that we received 2 working groups ago, the definition of live trainings has been modified to acknowledge that live trainings can in fact be recorded for future recording library bank, and need not necessarily always cover entirely new whole cloth topics as long as they're updated year to year to address the current state of ADR ethics and skills. The last thing that I think we talked about at the last full working group meeting was the fact that many of our entries have California based in brackets. My understanding continues to be that there will be able to agendize in a future working group, well, in our next working group meeting, a point to discuss interest in the state bar seeking statutory amendment to address the current scope of California Business and Professions Code 6173. With all that in mind, I would welcome Mr. Weiner, if you don't mind, if you could share your screen. And folks, I guess before turning to the group at large, I would invite my subgroup members if they have any corrections, additions, comments to weigh in, and then welcome questions and possibly a vote on one or more of the remaining items. Okay, nothing from my subgroup. How about the working group at large? Mr. Kelly?
I might have missed it, but in reading through the detailed descriptions, not the summary that's on this chart, I found something very confusing, which was that if I understood it right, a provider organization has to disclose its ownership structure and identity of owners other than affiliated practitioners. So anybody that's an owner and on the panel, you don't have to disclose. Same with equity owners, same with shareholders. Am I understanding that correctly, that that's the intent of the working group?
That is the intent of the subgroup. If you're open to it, Mr. Kelly, I would love to address it in the context of the administrative requirements that the providers worked on rather than in the tiers chart. But yes, that is the concept. And if you're okay with delaying that, we can come back.
Absolutely. I wasn't sure that I understood it correctly. If that is the intent, I'd like to understand why. Because if I were trying to figure out who owned this thing, I'd want to know if a panelist owned it also. So I didn't remember voting on that aspect of it in the tiers. So thank you. Please delay it to whenever you think it's appropriate.
Mr. Weiner, did you have a no?
No, I was just going to suggest what Mr. Kelly just said. I think, maybe for clarification, I think Ms. Ellis has, there are really three separate components to the provider organization subgroup recommendation. The first one is this tiers, and then there is one having to do with ethical obligations, and then there are actually two that have to do with eligibility requirements and administrative requirements. So that is down in one of those later items, Mr. Kelly.
Mr. Yamshan?
Thank you. I gather that live training includes webinars.
That was the intent of the subgroup, yes.
Okay,
So
thank
they could be in person or virtually conducted. Okay, is any member of the subgroup interested in calling for a vote on one or more of the tiers listed here?
If there's no comments, why don't we move it all?
I think that would be
Motion,
great. Cliff,
but-
are you making that motion?
Sure.
I'll second that motion.
Thanks, Ms. Lowe.
I'll go ahead and take the vote. Armstrong, Coulter,
Yes.
Curtis,
Yes.
Dinkin, Dubo, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Yes.
Jones, Kelly,
Yes.
Kopaken,
Yes.
Cruz, Lowe,
Yes.
Palevsky,
Yes.
thank you. Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes.
Motion carries.
Mr. Lucky? Judge Lucky?
Either one is fine. I wasn't called on the roll for either of the last two votes, and
Oh
so
my
I thought the
gosh.
first one was because I made the original motion, but I do vote yes on both.
Thank you, Judge Lucky. I apologize for that. You're correct.
No, no, I'm
For
I'm
some
sorry
reason,
to
your name is
interrupt.
not on this roll sheet, but I will add the yeses to both votes and make sure you're called going forward.
I'm not insulted. I just wanted to make sure that it was clear that I was voting yes.
Thank you. I apologize.
Thanks, Judge Jack, Mr. Lucky, Judge Lucky. To move on to part 2 of 3 of what the provider organization subgroup has presented for you today. In the same document that Alan just had open, there's an attachment 2 that includes some but not all of the ethics standards for state bar certified provider organizations that have been under discussion. We understand, thank you, Mr. Weiner, for throwing that up here. We undertook to create these and work together on these ethics standards upon learning that Senator Umberg's staff had reached out to the state bar about an interest in seeing such a rule set created. As you can see, we have a few remaining that we still need to go back and discuss, but we have today to present for you, I believe it's 5, forgive me, I can count through them. Fairness and impartiality, accessibility of services, complaint procedures, ethical guidelines, and confidentiality. And I did want to note in response to a question that we received the last time we discussed with the full working group, under complaint procedures, particularly under 7D, you'll see that it notes the ability of provider organizations to choose to also maintain an internal procedure for addressing complaints. So, but this is in addition to the requirement that the certified provider organization have a similar complaint coordinator and follow the similar state bar processes that were created for certified practitioners by this working group earlier this year. There's a lot here to look at, but does anybody, oh, I guess first I'll call on my subgroup. Anything further you wanted to add or comment on here? And then to the group at large, anybody at the working group, any questions that we can answer for you? Okay. Do any members of my subgroup want to make a motion? Ms. Curtis, please.
Yes, I had a question. Excuse me, I need to go back to my document. And so under 4C, fairness and partiality, it says a provider organization must adopt and adhere to minimum standards of fairness for consumer arbitration agreements. I assume that those are statutory, although I'm not an arbitrator, and so I wanted to just make sure that there was a way that standards of fairness is understood by practitioners.
Thanks so much, Ms. Curtis. I'm happy to take this, but Mr. Polewski, would you be interested in saying a little about this one?
Yeah, we do have the Armendariz standards, which are pretty basic and well accepted as legal minimum standards. JAMS and AAA have had their own set of minimum standards for years. They're pretty basic in terms of right to representation, adequate discovery, should have the access cost-wise, neutral arbitrator. I suspect firms who want to hold themselves to a higher standard can do that. But it didn't seem possible to even debate or get agreement as to specific standards within the time frame of what we're dealing with. But there are, in the Armendariz decision, pretty well accepted legal standards.
Okay, thank you.
Thank you, Ms. Curtis and Mr. Polewski. Any other questions that we can answer for the working group?
Could I just ask Mr. Polewski, for the benefit of the subgroup, could you talk a little bit about You had provided some of the standards from provider organizations that they have adopted for different types, and I think in addition to the Amadeus standards, it might just be helpful for working group members to understand that some provider organizations do have these minimum standards of fairness and how those work, or maybe you want to hand that off to someone on one of the provider organizations.
Right. Well, the most important, I mean, there are many important ones, but one that I forgot to mention was that you have to have the same rights and remedies that you'd have in a court. But the basic minimum standards were a neutral arbitrator, the same rights and remedies, cost efficient and adequate discovery. That's essentially it. There's been some debate over the years about how they are actually applied. We had a whole bunch of back and forth over the years as to whether shortened statute of limitations allows the same rights and remedies, which I certainly don't think it does. We've had some debates over the years, people going back and forth on whether class action prohibitions allow the same rights and remedies, and I don't think they do. But I think JAMS and AAA are the two that I know have standards, and they have people assigned to literally review. They require a review of the arbitration agreement before they agree to administer them to ensure that they comply with their interpretation of the minimum standards. I don't know that it's perfect, but I think it's really important and a very good protection against the most abusive clauses. There's going to be some gray areas and fights, but I think it's really important for firms to say, if you want to use us, your agreement has to meet certain minimum standards. I think it's very important for the integrity and the reputation of the firms themselves, and I really appreciate those that have done it.
Thank you.
I will add that to your question, Ms. Curtis, there are some statutory provisions in the California Arbitration Act that similarly do relate to this topic, including, I believe it's CCP 1284.3. Probably have that incorrect. But I think as mentioned, these minimum standards, at least what the subgroup thought was that in terms of the overall framework of what an individual provider organization wants to include in them above and beyond statutory or case law requirements would be something that would be for them to decide in their adoption and adherence.
Thanks, Ms. Ellis.
Can we answer any more questions for folks? Does any member of the subgroup want to move or make a motion?
I'll take a motion. Motion to approve the partial provider organization ethics document as dated, numbers 4, 5, 6, 7, 8, and 10.
Thank you, Mr. Welch. Do I have a second?
I will.
Thank you, Mr. Kolevsky.
I'll take the vote. Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Dinkin is absent. Dubois is absent. Ellis?
Yes.
Dr. Getz?
Angela, I'm sorry to interrupt, but I believe the motion was 4, 5, was it 4, 5, 6? Did it include 6?
7.
I will strike the motion of 6. My apologies if I so stated.
Oh, okay. Thank you. I'm sorry, Angela.
Okay, thank you, Judge Pichon. Dr. Getz? Higuchi?
Yes.
Hodgson?
Yes.
Jones is absent. Kelly?
I don't see 10 at all on my screen. Do I need to go back and look before I vote? Thank you. This is the same as we have been supplied. Yes, thank you.
Hopakin?
Abstain.
Cruz is absent. Judge Lucky?
Yes.
Lowe,
Yes.
Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
The motion carries.
thank you.
Thank you, everybody. So now we are on to part 3 of 3, which relates to administrative matters for provider organization certification. And in that regard, there was an additional report that the working group should have received, I believe, just yesterday. So apologies for the short time frame on that. But you'll see in it there are 2 different attachments. There's one for provider organization baseline eligibility and a second for program administration requirements for provider organization. And I'll be honest, this is something that I think I still had some questions about these documents, and so I do invite any further comments as we go along. As just one example, y'all might have noticed that we haven't offered yet up for vote ethics standard number 2, number 1, which includes definitions. But we do have a couple of definitions included in the baseline eligibility qualification requirements. So I hope that, I invite my subgroup here to continue the conversation if there are anything or any items we need to flesh out a little bit further. And maybe I'll, turn it over to y'all at this point. Does anybody have any questions, comments, concerns from the subgroup that they want to bring to the attention of the working group at this juncture?
Yeah, Miss Ellis,
Mr.
if I could
Weiner?
just mention, Miss Mia Ellis is going to be screen sharing and taking the lead and answering questions on this. So I don't know if you would like her to, and that's on both the next 2 sections. And so if you would like her to share screen, I think she's prepared to do that.
Thank you, Mr. Weiner. I appreciate that. And with that in mind, I think let's start with take these backwards and start with the administration requirements first. Ms. Ellis, I appreciate your help in screen sharing.
Absolutely, I'll do that now. I do want to, if I may, echo what you've already said in that your subgroup has been working very hard and had a meeting as late as Friday. And part of your discussion was included the program administration as well as the baseline. And so staff did not get the final document to the subgroup for review until I think it was Sunday, and appreciating that we didn't get it posted for the full working group until yesterday. And I know the subgroup may have additional comments and points of clarification. So we're happy to make those as we discuss it today. So thank you.
Thanks so much, Ms. Ellis. Subgroup members, any thoughts? I would welcome at this point in time too, if anybody would like to share anything in response to Mr. Kelly's earlier query about ownership. All right, subgroup or working group at large. Mr. Weiner?
Yes, I'll just share in response to Mr. Kelly's question. Something that came up is some provider organizations have all of their practitioners are shareholders, or many of their practitioners are shareholders. And I believe this subgroup's view was that might be expressed in kind of general information about the business, and that it might not be necessary to identify each of the individual practitioners who has a shareholder interest. I'm speaking a little bit out of my lane, so if any of the subgroup members want to correct or expand on that, that might be helpful.
Thanks, Mr. Weiner. Sorry, Mr. Kelly, go ahead.
I have to say, I would request that everybody oppose this because if the point is, if I want to know who owns the ADR company that I'm using, all I have to do is put an owner on the panel and then they don't have to disclose that they're an owner. Uh, I don't like that a bit. I think that subverts the intent of disclosing who owns something. And that exclusion is there in 3A6, and it's the same one in B3. Affiliated practitioners, meaning somebody on the roster, are excluded from the requirement to disclose. And I would strongly oppose that and ask that other people oppose that also. That's not a persuasive argument to me. And Mr. Weiner just meant that it might be inconvenient for people who have a lot of their panelists as equity owners. Thank you.
Thank you, Mr. Kelly. But Ms. Curtis?
Yeah, could you just give me the rationale for creating that exception?
Sure. Ms. Lowe, did you want to weigh in here? I'm also happy
Sure,
to.
happy to. And then if you want to piggyback after, happy to. So one of the things we did consider is, many of these affiliated practitioners, and I can speak from JAM's perspective, it's not a secret. We have affiliated practitioners who have an ownership interest. It is minuscule. There is no majority share. It is something we disclose in every case. If an arbitrator is an owner, that is also disclosed. So this information is disclosed throughout cases and not completely secret, but it does change quite a bit. And, the purpose behind knowing who might be an owner and whether or not they have an influence on the organization was really what we were focusing on, not someone who may have the tiniest 0.1% type of share in the organization. And so we were really looking for something that would really benefit the consumer and having that information, rather than just a list of individuals who really don't have much of a say. So that was a little bit of the thought process behind that from my perspective, if anybody else would like to add on to that.
Thank you, Ms. Lowe. That aligns with my perspective as well, including concerns raised by subgroup members about an organization owning a majority stake and then, say, hypothetically showing up in cases before the provider organization. That was really the situation that we were addressing and considering when we came up with these or had these thoughts. Ms. Hodgson?
With respect to the concern that it sounds like was raised at the subgroup, I'm curious if the subgroup considered identifying a particular percentage of ownership or something along those lines to address the concern while also, meeting the goal of public protection.
Thank you, Ms. Hodgson. I don't think we did I think at some point we had talked about majority ownership. Mr. Weiner, do you recall?
I think that may have had to do with the context of equity owners who were not practitioners in that context, and I think they would need to be disclosed if they were not practitioners. I think the question that Mr. Kelly raises about gamesmanship, by putting somebody on the panel so that their interest would not need to be disclosed, would be sort of a tricky method of gamesmanship, and perhaps that could be addressed by saying excluding disclosure of affiliated practitioners who have less than, I don't know what the percentage is, 1%, 5%, who have less than a very small percentage of interest. I'm also trying to align my mind with some of the discussions of other disclosures that are being discussed, but maybe have not yet been proposed, of business relationships that the provider organization has. And I'm trying to see if I can pull up a document while you're all discussing this that addresses the status of that, unless that's something that you recall, Ms. Ellis, or one of the other subgroup members remembers.
Perhaps Mr. Pilevsky?
Ron's point is a good one. I think that this is the administrative requirements to get certified. I do think we should require arbitrators to themselves disclose any ownership interest in their disclosure forms. I think that would address the issue. And administratively, it's a much easier way to go.
Thanks all. I will just piggyback on Ms. Lowe's comment to that extent and note that I believe it is already required in our consumer arbitrations, to Ms. Lowe's and Mr. Palevsky's point. Mr. Kelly?
I really understand an essential point of this whole effort to be transparency, the word that Senator Umberg used. And it's just beyond me why you'd want to make an exception of equity owners of any kind, whether they're affiliated practitioners or not. I think it's important for an organization to say who owns it if it's got ownership. And I think a consumer ought to be able to look on the organization's website and see who owns it, or that no one owns it if it's a nonprofit. If it's really intended to be transparency for a consumer, deciding whether or not they want to have their contract include AAA or JAMS or whoever as the designated provider, then I would really urge the group to consider whether or not who owns this organization shouldn't be something that's made available to the public as an ethical responsibility for being certified as a consumer protecting ADR provider. Thank you for letting me add that in.
Thank you. Mr. Welch?
Yes, and thank you so much. And I think it was stated, a little bit previously, but finding that potential of what is a substantial ownership equity share might be of benefit as, from a percentage standpoint. I know we talked about that already, but in our meeting, we didn't go through all of it. And there was talk of, majority stake, but that was a different disclosure. There was a lot of kind of discussion, but we really didn't hone down on what is that significant ownership share that might be reasonable for public awareness and all those pieces. That's just my reflection a little bit on that, or suggestion as we move forward. But I know that that's up for further discussion.
And to your point, Mr. Welch, Mr. Kelly, am I hearing you say that your view is that any percentage, smaller or large, should be included and disclosed on a provider's website?
I mean, my first take on this is to remove that phrase other than affiliated practitioners. But I'm not closed to the idea that if there's 500 of them because you make every panelist have a little bit of stock in JAMS or Signature, that's really irrelevant. I'm not sure it is irrelevant. If I'm a consumer trying to decide which organization I want to use and I have any choice in that, I'd like to see who owns it. And I think that's a reasonable ethical requirement. But, if somebody wants to say it doesn't make any sense if they own less than 1%, I'd be open to talking about that. It's the general principle I'm really trying to get people to look at. Thank you.
I think Ron's point is very well taken. And if it's not too early, I'd like to move that the language other than affiliated practitioners be stricken.
Mr. Weiner?
Yeah, thanks, Ms. Ellis. I just wanted to point out that on these last two documents that the subgroup is discussing, this document that you're looking at now is talks about what needs to be included in the application. There's some overlap between what needs to be included in the application and information that needs to be included on a provider organization's website, which is addressed in another document. I think it raises the same concern that Mr. Kelly has, but there is a sort of a corresponding requirement in the other document. Some of you may have it in front of you. J, the qualification requirement is maintaining a website that includes several enumerated items, including provides clear, accurate, and understandable general non-case specific information about the following aspects of the provider organization, services, and operations. And it, number 2 under that paragraph says the ownership structure and the identity of owners other than affiliated practitioners. So I'm just pointing out that this also comes up there. And if you're thinking about what you want to make publicly available, it's really the other document that lists what needs to be included on the website that is going to determine what's publicly available.
Thanks, Mr. Weiner. Mr. Kelly?
I'd like to see the state bar be able to certify that they are disclosing on their website all the equity owners because it's part of the application. That seems like a good way of having a cross check that what's on their website is actually listing all of their shareholders and owners. So I think these are completely related. Thank you.
Absolutely.
So I believe there's a motion on the floor. There's a couple different things we can do here. I suspect there might be someone who's interested in seconding, or the subgroup could also consider taking this back for further discussion. Although with only one meeting on the books, I would defer to the State Bar staff about how much we would want to take back into subgroup meetings.
It's proper. I'll second Mr. Yamshan's motion.
Just so I'm clear, we're in the program administration document, and we're talking about the initial and recertification application, 3A and B that's highlighted, striking these two and both of them? Is that the motion?
Yeah, and I think, isn't there a third exclusion farther down the document?
What Mr. Weiner was referring to is another document that talks about the baseline requirements.
Oh, I see.
I see.
Okay. So the motion does address the application to the State Bar.
Does that reflect the motion correctly?
Yes, thank you.
And that's a second from Mr. Kelly, is just confirming.
Yes, ma'am.
Is it okay to take the vote?
What can I just add? Is it the motion to just on this, on the application as a whole, or just this section? Or what is just so people have clarity?
I think that the disclosure should be made on the application wherever shareholders or equity owners are required to be stated.
Okay, so just taking this attachment to, I just want to make sure that the motion is clear and what we're voting on, the record's clear. These program administration requirements, there's 4 of them. Number 3 covers what should be in the application. Is the motion to vote on all 4 of them or just number 3?
Yes.
Okay.
That's the intent of the motion. And Ron, is that the intent of your second?
Well, that's why I asked what's proper procedure here. I'd like to see those sections stricken the way Mr. Yamshan's motion reads. Are we being asked now whether or not the motion says approve everything else as part of this motion?
Well, we were on number 3, and it's 3 and then number 6, and then that's under A, and then B, 3 under B. So if that's Mr. Yamsham's motion, we should take that first, and then we can go on to the other sections.
Yeah, let me clarify that it is not a motion to approve the entire document as amended by striking the other than affiliated practitioners. It is a motion to strike that language while allowing the entire document to be considered.
That I would certainly second, if it's a proper motion.
I hope it is.
Is that just related to number 3 or
No, it is to all 4 places
wherever it's said?
other than affiliated practitioners. It
Okay.
has been offered.
Can I just as a point, these are there, it's also noted in another document. So can we just, since there are 2 different attachments, can we just take those separately? Just so the record's clear, please. Or we can,
I'm not sure what we're being asked.
so I'm going to switch
So,
to
Mr. Yamshun, I think, as I mentioned, there's another document that states what needs to be specified on the provider organization's website. And Miss Mia Ellis is requesting that that document be looked at separately. Presumably, you'll want to remove the similar language there, but just for purposes of the clarity of the motion and the record, if we could address them one document at a time.
Yes, that makes sense.
Thank you.
Okay.
Can I just raise a question that is on my mind because of the discussions in the subgroup? And this relates to some of the other things that at least may come up later or may come up at the next meeting. But there's a question, when there's a continuing obligation. So if, for example, this document right now we're talking about, initial and recertification applications. But if something changes between the initial application and the recertification application, there may be a practical concern about how, if JAMS takes on a new provider or a new practitioner who becomes an affiliated practitioner with an equity stake, I think there will be concerns about whether that needs to be updated, whether the application needs to be updated every time there's a change like that, or whether that can just be done in the initial and recertification applications and sort of catch up at that time. And I'd also mention that there may be practitioners who go off the list, if you will, who are no longer affiliated practitioners and may no longer have an equity interest. So just trying to think about the practicalities a little bit.
Well, I will throw that back to the subgroup to determine whether there's an ongoing duty. Certainly, with a lot of the discussion in the tiers group in terms of reporting, we decided there is an ongoing duty. But I think that's something for the subgroup to determine whether or not there is an ongoing duty, because they're the ones who have the expertise in provider operations.
I realize that Ms. Jenna Ellis is concerned about the amount that is returned to the subgroup that we will reconsider at the next meeting. But since there is so much discussion here, maybe it might be appropriate if the subgroup does reconsider this along with the comments that have been made. But that could only happen if Mr. Yamsham does not want to proceed with his motion and the second. I'm sorry. Ms. Ellis, do you want to call on Mr. Kelly?
Sure. Mr. Kelly?
Would it be acceptable, Mr. Yamshan, to simply say, but that both of these be rewritten to say that general business information would include the identity of equity owners which shall be an ongoing obligation, and a description of shareholders, which shall be an ongoing obligation. Would that be clear enough to send out for public comment anyway?
Yeah, I think I'll take that as a friendly amendment. And since you're the seconder, I guess it's already been seconded.
I'd just like to again raise the concern about, so does that mean that every time there's a new JAMS practitioner who, for example, who has an equity interest, that they need to update their application and their website? I mean, I think that's the implication of making it a continuing obligation as well as an initial one. So just
Yeah, if I might comment, given the disclosure requirements we're imposing on all practitioners, this doesn't seem like a big deal to me.
Yeah, that's exactly
again,
what
I'm not a practitioner. I'm not a provider organization. So it's up to Ms. Ellis, I think, whether she wants to take it back to the working group and talk more about this. I think the point is clear. I understand that there's a friendly amendment here, which has been accepted by the maker and by the seconder. Is it appropriate to discuss that friendly amendment?
Yes, and Ms. Hodgson's hand is up.
To Mr. Wiener's point, as far as the administrative difficulty, I wonder if there could be some sort of compromise reached where there's one obligation with respect to putting the information on a website or provider organization's website. I imagine they're already going in and updating a website to announce, hey, we've got a new practitioner here. And a separate obligation regarding timing as far as updating their application, whether that is upon renewal, whether that is on an annual basis, just with respect to not a renewal, but updating kind of their roster for certification purposes. Something like that might be a way to split the difference between administrative burden and consumer protection.
Thank you, Ms. Hodgson. And apologies for my quietness on this. And in terms of process, I appreciate that there's a motion and a second on the table. It sounds like there's an invitation that falls on my shoulders of whether my group would want to take this back and discuss it further. I mean, certainly to Mr. Kelly's point, we can. I don't know how much more we'll be able to add compared to what we've already learned, I think, and heard in the last 5-10 minutes on this topic. I would invite the input of State Bar, given the fact that we have just one more working group meeting and not much time before that meeting takes place.
And Ms. Ellis, I saw one more hand. Was that Mr. Welch?
I believe so.
Yeah, sorry. I mean, I think it would be good for the working group to figure out what a real ownership stake is of an affiliate practitioner that comes in. If it's 0.25%, 0.5%, 0.1, like what is significant and what kind of comes into play from a consumer's perspective if there's a threshold. I am more than okay. Also, disclosure that I'm a nonprofit that doesn't quite affect me as much, but I'm just trying to see if there's a balance there for that. But I totally understand the need for transparency and working through that. Just those comments.
Mr. Palevsky?
I agree disclosure is important. There is a disclosure requirement in the ethical rules presently. I think any financial relationship or affiliation the arbitration has with the provider organization, other than including financial interest in the organization, that's for consumer cases. So I think disclosure is important, and I'm not aware of the burden because I don't know how many people are out there, but I do think it is very relevant if any practitioner has a financial interest in maintaining customer-client relationships in the overall profitability of the firm. That's it. So I don't really think the amount of your ownership is even if it's minimal, I do think it's relevant. So I know that there have been people in the National Academy who did not think arbitrators should ever have a financial interest. That's not the law. but I do think it's relevant whether you have an interest in the overall success of the business. So I'll
Thank
take
you,
it.
Mr.
I'll go back.
Pulaski. Thanks all. Well, to be honest, hearing nothing from Ms. Ellis or Mr. Weiner, I would think we should proceed with the vote.
Can I make sure I have the Mr. I think it was Mr. Kelly's friendly amendment? Is this, have I captured it correctly? Or I don't think, I feel like it's incomplete. I was trying to capture what you said.
Well, it looks good enough to me to send out to public comment, which is a standard we've been using so far. That, trying to get it absolutely perfect. I don't have any improvement in your language. Thank you for asking.
Mr. Yamshon, I think it was.
It's fine. Thank you.
So is the motion for this language to go also under B?
Yes.
Or with B instead of B? Yep. Striking.
And then we have two more.
Two more?
Farther down, I believe.
Oh, here.
Or maybe that's the other document.
Oh, I think that's the other document.
Okay.
And we can put that when we get to that document. That's
right.
Okay.
Sure. I apologize.
No problem. So just also, if I may, Judge Pichon, this is what the resolution looks like as we take the administration motions. Resolve that the ADR certification working group approves and concept program administration requirements for provider organizations. Paragraph number, in this case, it would be 3A6 and 3B3 in attachment 2 to the January 21st, 2026 provider, spelling here, organization subgroup supplemental report and recommendations for agenda item B 2.2. And in this case, it would be as revised during the working group meeting and for distribution for public comment.
Question, if I may, Miss Ellis, Miss Jenna Ellis. I'm just wondering, so there's been a lot of conversation about this, and there's a motion to approve this. I'm wondering if there are other revisions that people would like to see made to the document, or whether the motion, if not, whether the motion might be made, revised again, amended again to approve the document with this amendment. I know Mr. Yamshan said that was not his intention initially, but if there's nothing else to be changed, that may be appropriate and efficient.
Mr. Weiner, with all due respect, Ms. Ellis called the question.
Okay.
Sorry. I don't know if I follow Mr. Yamshan's comment, but
They said let's vote, and the call for when you do that, that's a call for the question under Robert's rules, and discussion is terminated and the vote must take place. Sorry to be a curmudgeon, but I didn't write the rules.
What about Rosenberg's rules?
right.
And this is Ron, as the second. My understanding, again, is that a call for the question is requires a separate vote. I don't think one person gets to say, we're going to cut off discussion and vote now. I don't know if Ms. Ellis made a motion to cut off debate.
Okay, I'm not sure that's correct, Ron, but all right. I'm not going to argue.
But I think your intent is my intent also, that we vote just on excluding this, and then if somebody wants to make a motion to approve all the rest of it or change the rest of it, they can do that. But my hope is that we just focus on this issue. Maybe it'll go up, maybe it'll go down. Thank you.
Ms. Ellis, would you like for Angela to take the vote?
Sure. That would be great. Thank you.
Take the vote. Armstrong is absent. Coulter?
Actually, Angela, I'm sorry. Can we have a restatement of exactly what we're voting on, just so it's clear in black and white? Was it the last thing Ron said? We're all over the place, and I hate to delay things any further, but I want to make sure I'm voting correctly.
It's not a delay to ask for clarification. That's fine.
Okay.
We
Ms.
had-
Mia, apologies. A part of this is that the double Ellis's, I think, is slowing.
Oh, is it that for me? Did you
well,
want
this is not my motion, to be clear, not my second. So but I am mindful that we have only one meeting left, and that there is a pending motion on the floor by Mr. Kelly. I have not called to end debate.
Right.
But Ms. Mia Ellis, would you mind clarifying what the vote is?
Before Ms. Mia Ellis does that, Judge Lucky has posted in the chat what Rosenberg's rules say. Judge Lucky, would you state what you found?
I think it's moot now, but just calling the question is a motion, and it does require a 2/3 supermajority vote to approve.
All right.
Thank you.
Well, I learned something. It's different from Robert's rules.
Yeah. Okay. So, Ms. Mia Ellis, you were going to say something?
So just for further clarification on the motion, and it was friendly amendment from Mr. Kelly and Mr. Yamshon seconded. So if I have it wrong, please correct me. I think that it appears the resolution is that the ADR certification working group approves and concept program administration requirements for provider organization paragraphs number 3, 6, and 3B3 in attachment 2 to the January 21st, 2026 provider organization subgroup supplemental report and recommendations for agenda item B 2.2 as revised to include language that general business requirement / disclosure includes identification of equity owners, and it is an ongoing duty to disclose and update information. And that language would be in the initial and recertification application under 3A and 3B.
Thank you so much, Ms. Mia Ellis.
If I may, Mr. Kelly, did I get that right? And Mr. Yamshon?
Yes.
Yes, thank you.
I'm ready to vote.
I would invite the chair to call the vote.
Ms. Jenna Ellis, I think you said earlier you were ready for the vote. So is that your position now?
That was me. That was me because
oh,
I asked for clarification. It's Claudia.
Right. Ms. Coulter, I was talking about before you said that, Ms. Jenna Ellis had said a little bit earlier, or maybe that was you, but Ms. Jenna Ellis, did you ever say that you were ready for the vote?
Yes, I believe we're ready for the vote, Madam Chair.
Okay, well, take your time. Be sure that's what you'd like to do.
Let's vote.
Do you need any other member of your subgroup to weigh in?
I don't believe so.
Okay.
I believe we can call a vote.
And then Ms. Coulter, you said you're ready to vote.
Yeah,
Is that
right. Because
correct?
sorry, Judge, I asked for clarification. I feel like I got the clarification. I think we're all
Okay.
clarified.
Okay. All right. There's a motion and a second. Angela, would you please call the vote?
Sure. Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubois is absent. Ellis,
Abstain.
Dr. Getz, Higuchi,
No.
Hodgson,
Yes.
Jones is absent. Kelly,
Yes.
Kopaken, Cruz is absent. Lowe,
No.
Lucky,
No.
Kolevsky,
Yes.
Robertson,
Yes.
Tuckman,
Abstain.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
No.
9 yeses, 4 noes, and 2 abstains, so the motion carries.
Thank you. Okay, I'm turning it back over to you, Ms. Jenna Ellis.
Thank you. I will just personally note that I have 2 points in this document that I wanted to call to folks' attention. First, in item number 1, it refers to a designated contact person. My view is that this should be 1 or more designated contact persons, because I think that more closely aligns it with the other attachment that was prepared with the administrative aspects of provider organization qualifications. The other thing I wanted to flag for folks is number 4. Fees for provider organization should be based on organization size, including a range of affiliated practitioners. My view is that the fees should be based on the number of compensated cases that are, in brackets, California based, that are conducted by a particular provider organization. So those are areas where our subgroup had robust discussion, and just 2 that I wanted to draw to your attention where we had ongoing conversations. But I welcome any other comments from the working group at large, including subgroup members. Mr. Yamshan?
I'm just wondering what the rationale would be for fees being based on size, because GMs and 3A are huge in the industry, and there's smaller organizations such as Coast to Coast Mediation down in Southern California. Judicate West is fairly sizable, might be considered a mid-range organization. And I just don't understand the rationale, because if the neutrals are every bit as skilled and the cases are every bit as complex amongst the providers, why should fees be based on size?
I would invite another member of my subgroup to respond if they have any thoughts here, or the State Bar staff, and then Ms. Curtis after that. I turn to you.
Oh,
Great.
should I just go ahead?
Yeah, thank you.
I understood this to mean fees to the state bar for application fees, not fees charged by providers. But anyway, and in that case, the size and I don't really know what range of affiliated practitioners means. I
Thank you,
think
Ms. Curtis.
size makes sense, but I'm curious about the other qualifier.
Yeah, if it's fees to the state bar, that does make sense.
And that, I believe, was the intent. We're getting a nod from Ms. Mia
Yes.
Ellis.
Yes, that was the intent. That was the focus of the conversation or fees to the state bar. I
Mr.
can add
Weiner?
Yeah, just a little bit of history here. The program administration subgroup had earlier, quite some time ago, made a recommendation that fees for provider organizations should be based on the number of practitioners, and that there should be then a credit for practitioners who are certified. And that recommendation did not carry with the full working group. I think largely because of concerns that were raised by provider organizations. So that's just a little bit of history about how the size of the provider organization came to be a somewhat of a measure for what the certification fees due to the state bar should be.
So what is a range of affiliated practitioners?
Yeah, so the idea would be if you have 1 to 5 practitioners, there's a fee. If you have 5 to 25, there would be a fee, 500 to 1,000, there would be bands basically, the ranges. And part of the complication here, if you will, the program, as you all know, needs to be self-supporting. So the State Bar's finance division is going to be working with Miss Mia Ellis to try and figure out what sort of certification fee structure will satisfy the statutory requirement that the program be self-supporting and that state bar licensure fees cannot be used for it. And so the guidance, I think, that is being requested and that is in order from the working group really is, what would you like Miss Mia Ellis to take to the finance division when she sits down with them about, what do you think is a good way to do this?
So I still don't understand affiliated practitioners. What is that? Are those the practitioners would be arbitrators or mediators, I assume. And what does affiliated mean? Affiliated with the anyway, I'm sorry to be kind of dense about this, but I don't understand it.
If I
I
may,
mean,
I'm
I
sorry.
understand the range concept, but the last part I don't understand.
There's a definition of affiliated practitioner.
Ms. Mia Ellis?
Yes, I was just going to say exactly that. On the baseline requirements, there is I think as Ms. Jenna Ellis said in the first, there are a couple of definitions that are included for baseline, including how do we define provider organization, as well as what's considered a affiliated practitioner. So those are items to be discussed and voted on by the working group.
Mr. Tuckman?
Thank you. Actually, just put my hand down because I think the notion of affiliated practitioners is something that I had raised at one point. And just thinking about, again, the AAA as an example, we have a panel, but there are many arbitrators that are appointed to cases that aren't part of our panel. Parties are free to do that. They can select the arbitrators that they desire. So, and we have less involvement and connection with them. They might be appointed to a case, but we don't have them on our roster. They're not listed. And so the desire was to just clarify.
Okay, thank you.
And Mr. Tuckman, I was just curious if you find that the definition of affiliated practitioner that Ms. Mia Ellis just showed is consistent with kind of the explanation you just provided.
It is, and again, we're not, I don't want to wordsmith, the notion selected unilaterally by a party did jump out at me. It does generally fit within what I just described, but it's not always one party that has picked them. It's not always a party appointed arbitrator. Sometimes parties have come together to pick their chair. But again, I think for what we're doing here, that explanation, that definition works.
Thank you. Thank you for indulging me on that. Mr. Kelly?
Thank you. Well, I think I understand what that definition is trying to get at, and it gets at the problem that Mr. Tuckman has just identified. I mean, I've been on AAA's panel and the state of California's panel as an arbitrator for years and years, and also done my own private cases. And if I were with the state bar or with AAA or any other provider organization, this definition would not be very clear to me, like it's not clear to Ms. Curtis, I think. At least it's not that definition I really hope we work on at some point, because I think it'd be tough for somebody, either a provider organization or the state bar, trying to determine compliance, to figure out what that definition really means without an explanation like Mr. Tuckman just gave. Thank you.
Thank you, Mr. Kelly. Well, are there any other areas of this document that we currently have up that folks would like to discuss or talk about? Mr. Kelly, do you have your hand up for additional comment or? Okay.
I apologize.
No problem at all. Well, if there is no more discussion, I would invite my subgroup members to consider any votes they might, or motions that they might want to bring on this document. Does anybody want to bring a motion for item number 1?
I'll move adoption of item number 1.
I'll second for item number 1.
I'm sorry, who was the second?
Kim Lowe.
Thank you. If I may ask, is that including one or more here? I think Ms. Ellis, you mentioned that.
I defer to Mr. Tuckman and Ms. Lowe.
I don't, well, that's fine. One or more is fine.
One or more
So
was my understanding.
Yeah. The motion is to include one or more within item number 1.
I don't want to be, I don't want to imply that I'm cutting off discussion. So at this stage, does anybody else have any additional discussion they'd like to bring regarding the motion? Madam Chair, I believe I can turn it over to you at this point, or perhaps.
Well, yes, you have a motion and a second for number 1. So it's just, and there's no more comments. So just, we'll ask Angela to call the roll. And that's on item number 1.
Armstrong is absent. Coulter.
Yes.
Curtis.
Yes.
Dinkin is absent. Dubois is absent. Ellis.
Yes.
Dr. Getz.
Yes.
Higuchi.
Yes.
Hodgson.
Yes.
Jones is absent. Kelly.
Yes.
Kopakin is absent. Cruz is absent. Lowe.
Yes.
Lucky.
Yes.
Pileski.
Yes.
Robertson.
Yes.
Tuckman.
Yes.
Welch.
Yes.
Yamshan.
Yes.
Judge Pichon.
Yes.
The motion carries.
Can Ms. Jenna Ellis, if you wanted to take them one at a time, we can do number 2.
That sounds great. Madam Chair, I defer to you whenever you'd like to take a break too.
Oh, okay. It is time for a break. So why don't we do that? It's 3:47 and we'll take a break until 4 o'clock. Alice.
Thank you, Judge Pichon. Welcome back, everyone. We just voted on number 1 in the document that Ms. Mia Ellis has up on the screen. As you can see, there's numbers 2, 3, and 4 left in this document. Does anyone in my subgroup have, would anyone like to make a motion regarding item number 2?
I'll make a motion for 2, 3, and 4.
Thank you,
Unless you
Mr.
want to take them separately.
I second.
Ms. Curtis?
Well, I was curious about staff's feedback about the frequency of every 3 years, because it seems to me it could have a pretty significant impact on the revenue.
If I may, Judge Pichon and Ms. Ellis, I believe, if I'm recalling correctly, that's the frequency that the working group voted for the practitioners. So it would be a similar time frame or for the provider organizations. So we would want it to be consistent.
If I can add, I think the other facet of it, to your question, Ms. Curtis, is that that doesn't mean that fees would only be due every 3 years. There would likely be an annual fee due, but the full recertification application would only need to be resubmitted every 3 years.
Okay, thank you both.
Any other discussion? And just to make sure I understand the vote or the motion, my apologies. I believe Mr. Palevsky made a motion for 2, 3, and I understood that to mean the remainder of 3 and 4, and that was seconded by Mr. Higuchi.
Yes.
Did I see a hand, Mr. Kelly?
Thank you. So I don't have to dig it out. Could you put 4 on the screen for us, please? Because that has to do with how much everybody has to pay for this. And I know there was some discussion about different ways of approaching this. Just want to be sure everybody's comfortable with this particular way of approaching it. I don't have a problem with it, but I don't exactly understand it as being very specific. Thank you.
Thank you, Mr. Kelly. I'd defer to others in the subgroup who might want to weigh in on this, as well as State Bar staff. I think y'all have heard my alternative thoughts on this one. Ms. Curtis?
Yeah, I would make a friendly amendment to just have this go back to the working group for clarification, because I think I'm not the only one who is confused by it.
If I'm
I
understanding,
mean, back to the subgroup, I'm sorry.
thank you, Ms. Curtis. If I'm understanding the friendly amendment, the result would be that an amendment to modify the motion to just address 2 and 3, and then for 4 to return to the subgroup for further discussion.
Yes, exactly. Thanks for the clarification.
Mr. Weiner?
Yeah, I just wonder, I think we may have more time in this meeting today, ironically, than the subgroup may have at its last and final scheduled meeting. And I'm just wondering whether we might be able to address the concern about where it's unclear. It seemed like the questions before had to do with what is an affiliated practitioner. And I thought perhaps that was answered by the definition that Ms. Mia Ellis shared. Essentially, saying it's a panelist. I think essentially saying it's a panelist.
Well, here's how if we're wordsmithing, could you go back down, please? Yeah, so I don't know that you need including a range. That was what really threw me, because or based on organizational size, that seems to me that's something that can be worked out by the state bar, as I understand it, like between 2 and 7, or 2 and what, or 7 and 20, or however that I don't think that has to be precise here. So if that comes out, including a range.
Well, I think the challenge with that, if I may, Ms. Curtis, is one of the things the subgroup had to say was, well, the size of our provider organization changes. People come off the panel, people go on the panel, particularly if that's going to be the basis for an annual fee. At what point in time is the size determined? And I guess another concern that I would have about making it the size of the organization, does that include staff? Does that only include practitioners? So I think that's what the range was aimed to.
What? I'm sorry. What is range? Just
5 to
define.
50.
What?
1 to 5, 5 to 10. A range of the number of practitioners, a range from number 1 to number 2. As what was, I mean, that's what it is intended to say. If there's another way that that could
Yeah.
be described, or that you see that that could be described or clarified.
Mhm. Mhm.
I mean, maybe by saying a range of the number of affiliated practitioners, or by ranges of the numbers of affiliated practitioners, or bands of the number of affiliated practitioners.
I think bands makes more sense to me. I'm not sure that answers anybody else's concerns, but that makes sense.
Ms. Hodgson, sorry, Ms. Curtis, if you had more to
No.
share there.
I'm hoping to clarify because I agree with Ms. Curtis that the phrase that is not working for my brain is the phrase including a range. So maybe if we switch out that language for the sake of clarity to say based on organization size, um, including or like as specified by the number of affiliated practitioners or something like that. So, because including a range makes it sound like it's almost a different thing than how the organization size fee is being determined.
Thanks, Ms. Hodgson. Mr. Weiner, do you want to, or sorry, Ms. Mia Alice, are you playing around with the language now to reflect, or?
I can.
I guess in the meantime too, I'll invite Ms. Lowe. I see you have your hand raised as well.
Help if I unmute. Thank you. So mine is not so much about the range, but I think something that we've discussed a lot throughout our subgroup is the idea of limiting certain things to California. I'm not sure affiliated practitioner has that in the definition. I don't recall, but to subject a provider organization to have to pay fees based on practitioners that are not in California would not be subject to any of the state bar certification doesn't make sense for consumer protection, in my opinion. So I would love the working group to consider that because I think a lot of our organizations do have a lot of practitioners everywhere, and I'm not sure that that would make sense to be included.
Mr. Kelly, Ms. Mia Ellis, did you want to jump in there?
Oh, I apologize. Ms. Hodgson, I want to make sure I've captured what your language is, so I can have it on the screen.
I think, and I was just kind of spitballing, so I apologize if this isn't exactly what I said before. Should be based on organization size as defined by number of affiliated practitioners or something along those lines.
Or as determined.
Determined is good too. I like it.
I do agree with Ms. Lowe's comment and would love to follow the same pattern we have in other places of using California-based in brackets.
California-based practitioners?
Yes.
Makes sense.
Mr. Kelly?
I'm also very much in favor of limiting it to California-based practitioners, and I'm glad that people are talking about number 4, but I don't know what a California-based practitioner is, given that anybody anywhere in the country can do California cases. I don't know what a California-based practitioner means.
I hear you, Mr. Kelly. I do think that this is a tricky issue. It's one that the provider subgroup has discussed in the past, and we are still kicking around, for example, a ethics standard relating to applicability. My understanding is that, at least for example, in the tiers documents, we've been using this California-based in brackets as shorthand while we continue to explore the exact contours of that. For example, I believe Mr. Weiner has suggested questions related to number of cases, volume of cases by a practitioner, the physical location of the practitioner. But I know that those do, to your point, offer some tricky questions.
So I think the wording was as determined, or was it as defined? And by number of, I think was what I heard.
Me too. Thank you, Mr. Kelly.
Thank
you. Mr. Welch?
Yes, thank you, Ms. Ellis. I wanted to just speak to the community-based low-cost or no-cost service providers, just to make the note publicly about, potentially a tier or something for them, just for the state bar to have in their considerations. If it's not noted here, or at least somewhere that maybe there is some consideration for some type of reduced fee in those no-cost, low-cost service providers.
Thank you, Mr. Welch. This has been on my mind as well. And I have been thinking about, say, hypothetically, an organization with many affiliated practitioners who each do a small volume of work versus a smaller organization where each affiliated practitioner does a significant volume of work, and wondering, similarly, maybe more of a corollary than exactly the same as Mr. Welch's example, what, if any, impact that should have on fees assessed. Mr. Weiner?
Thank you. I guess a couple of things. One, if range is being dispensed with, I wonder if the working group's intention, for those who are making the revisions, would intend or agree that it should be at least based on the approximate number, so that it's not, if you have three, if a provider organization has three practitioners, it necessarily needs to be charged more than one that has four practitioners. And maybe approximate would be somewhat of a proxy for what range was intended to accomplish. I also was going to provide a little bit more information about the bracketed, affiliated, or California-based, which, I agree does need more definition. And it's also tied to a number of other factors that, as Ms. Jenna Ellis said, the subgroup is still working on.
Thanks, Mr. Weiner. Ms. Curtis?
Yes, so I wonder if this would work. Should be based on ranges of organizational size, or based on an organization size by ranges, because I do see what that might be helpful. The other thing is, did this subgroups think about annual revenue as one of the ways to deal with this reality that you mentioned a minute ago, Ms. Ellis, about how it could be a small organization but bring in, a huge amount of money. And that also maybe addresses Chris's point too about organizations that are nonprofit and they don't actually bring in fees. They operate on funding from the legislature, as in DERPA cases.
Thank you, Ms. Curtis. I'm not certain I recollect, so I would invite other members of my subgroup to share if Mr. Palevsky?
I agree with Chris and Dana that revenue, there may be revenue, certainly for nonprofits, should be considered. I don't, I was of the mind that maybe letting the state bar start to figure out what the revenue requirements are. And maybe we can make this should consider things including. So maybe it does make sense to refine this definition to create more flexibility and to take into account nonprofit status and things of that sort, rather than dictating one size.
Thank you for
Curious
that.
what Mia thinks. Excuse me, Mia Ellis thinks.
Well, I do think, as we've talked about before, that it's what the fees are for the program, whether it's and certainly an annual fee, a recertification fee, and a initial fee for the program. The bar will still needs to figure that out and determine what those fees are. Will they be based certainly for individual practitioners? Arbitrators, mediators, but also what those will be based on for provider organizations. So I think it's best to leave it to the state bar. However, given that there are some recommendations here, if the group wants to give some guidance or insight to the bar in terms of what to consider, we would take those recommendations as well. But it is something that we need to confer with our finance department to determine what those fees should be.
Thank
I'll
you,
amend my motion to withdraw 4 from the motion, if that would help.
So, Mr. Palevsky, I'm hearing you are amending your motion to move for a submission for public comment of item number 2 on this administrative requirements for provider organizations, and the remainder of item number 3. Mr. Higuchi as the second. Do you agree with that modification?
Yes.
Does anybody want to have any discussion on items 2 and 3 before we move to vote on those, and then flip back to a perhaps more conversation on this item number 4, or perhaps take it to subgroup? Any other comments on 2 and 3? I'm not hearing anything, Madam Chair, so I wonder if it might be time to call for roll.
Yes, it is. Angela, would you please call the roll?
Armstrong is absent. Coulter.
Yes.
Curtis.
Yes.
Dinkin is absent. Dubois is absent. Ellis.
Yes.
Dr. Getz. Higuchi.
Yes.
Hodgson.
Yes.
Jones is absent. Kelly.
Yes.
Kopakin is absent. Cruz is absent. Lowe.
Abstain.
Lucky.
Yes.
Palevsky.
Yes.
Robertson.
Yes.
Tuckman.
Yes.
Welch.
Yes.
Yamshan.
Yes.
Judge Pichon.
Yes.
The motion carries.
Thank you. Ms. Marlad, Mr. Weiner?
Yeah, I was just going to suggest regarding number 4, I don't recall who made the suggestion, but I'm thinking of wondering whether something like in setting fees for certification of provider organizations, the state bar should consider matters such as the number of practitioners, the annual revenue, et cetera. And rather than making it a kind of a concrete, this is the item, recognizing that the state bar's finance department is going to have to be looking at it and, making judgments as to what's going to sustain the program, and maybe just giving guidance as to things you think it should consider, whether that might be amenable to the working group.
I'd invite any thoughts, comments, etc. from the working group members.
I would say I second that approach to give some guidance but not restrain. Because now I can't remember who made the point, but we got to think about, smaller nonprofits or programs being impacted. If it's just by size number, I think that creates more flexibility. So I'd second an idea like that of including but not limited to these suggestions as people have discussed.
Thank you, Ms. Robertson. Any other thoughts?
I think it was my suggestion, but if we're just, and I think it makes sense. But if we're just going to say here, consider all these factors, do we need any rule at all? Or isn't it obvious that they got to consider those factors? I mean, if you think it's helpful, Alan, we can do that.
Yeah, I think it's a question. First of all, I don't think this is in the context of a rule here. I think this is in a context of, if the working group has views of what it would like the state bar to consider, this is a place to put them. And I think the including but not limited to approach, since there have been, a number of different ideas floated from, revenue practitioners, nonprofits, maybe if you just provide your thoughts on that, or maybe if you don't, I don't think you're obliged to, if you don't feel it's important to the working group to provide that kind of input, then I think you could just dispense with it.
Ms. Curtis?
I think it would be important to have something here so that people can comment on it. If we leave it off, then where does that feedback come? How does that feedback come to the state bar or to our working group? But I think the idea, and I would word it a little bit more strongly, that in setting program fees, the state bar should consider the things that we've talked about so that it's not among other things, in other words, and because I do think that we have, if not consensus, and we have, I think in concept, we have some, at least it seems a majority for a few things, and then people can add or give feedback about whatever it is they like or don't like or would like to add.
Mr. Weiner, I see you came off mute. Did you want to respond to?
No, I was simply asking my dog to quiet down. But thank you.
I see Ms. Mia Ellis is putting together, kind of compiling the list here. It sounds like we have at least an agreement from a couple of working group members to an approach like this. Are there any other items that we might want to include in this list?
I would say it should be determined by, and then take out by one. In terms of how to calculate size, it might be number of practitioners rather than just size, number of, I forget the term that you used, but affiliated California-based practitioners.
And I believe we also discussed revenue.
Yeah, revenue.
I don't hear other folks thinking that looking at the number of California-based cases is something we might want to add, but Mr. Kelly, did you have another thing to add?
I really think it makes a difference if it's a community mediation program or a for-profit ADR provider. Exactly how to phrase that, I don't know, but I'm not sure the exact phrasing is important.
Nonprofit status.
Thank you.
I was going to say that. Thank you.
Ms. Curtis?
Yeah, I would change in line 1, should include it, and change include to should be determined somehow or by, but not limited to.
What about be determined by a variety of factors, including but not limited to?
Well, I was trying to get to the point that it should include these things that we've been discussing, but may not be limited to them. So however that gets communicated.
Mr. Kelly? Sounds good. Ms. Curtis, I'll defer to Ms. Mia Ellis and Mr. Alan Weiner on the wordsmithing. I think you're right about that we're on agreement and concept. Do
Yeah, that looks good to me.
okay, great.
Question.
Mr. Weiner?
Yeah, so just it might be helpful to have some clarification about the nonprofit status. For example, would you put American Arbitration Association on the same basis as a community dispute resolution program?
No.
With a, yes.
Ms. Hodgson?
I will say I'm generally in favor of this idea, but I am concerned that as currently phrased, it is pretty vague. And although I am not a provider organization, if I were, I would be apprehensive to apply not knowing what my possible fee could be. It feels a little more arbitrary than the prior language.
Mr. Weiner?
Yeah, to Ms. Hodgson's point, I certainly agree that either practitioners and provider organizations are going to want to know what their fee is. I would anticipate that the state bar will, work out an equation that would give practitioners and provider organizations that information before they apply. It wouldn't be sort of, here, tell us what we owe. At least I would hope that there could be a formula that organizations could determine what their fees would be.
Yes, if I can just chime in, can never find where to raise my hand quickly enough. Yes, to Mr. Weiner's point, that will certainly be when it goes before the board. We will have conferred with finance to make that information available to the board. And I'm not sure if it will be available at the time we do public comment as directed by the board, but certainly when it returns to the board, that should be something that we should know by then for practitioners and provider organizations.
Mr. Kelly?
I'd like to ask Professor Robertson to weigh in as a clinical professor at a law school. I understand there to be quite a number of law school programs that are providing ADR services. Should there be some reference to that in this? And I don't know the answer to it, but I'd like to hear something one way or the other if Professor Robertson wants to weigh in.
I cannot speak for all clinical programs, but I would think that the clinical programs in themselves are not going to want to be certified as providers because we're utilizing students as the mediators in an academic setting, and they're supervised by professional mediators, professors, and other supervised mediators, depending on the program, who themselves could be certified, but I wouldn't call them sort of a provider org in that. Generally, we have like a community partner we work with specifically, and we're not just providing general mediation services to anyone in particular. It's through these community and court partners, specifically under like MOUs or other agreements. So I don't think it's quite applicable to clinical programs.
Thank you.
Mr. Weiner?
Thank you. I was just going to suggest maybe something more broadly, instead of saying community mediation program, nonprofit versus for-profit, just say organizational characteristics and make those maybe examples. And that could point to, educational programs and government programs and such.
Thank you, Mr. Weiner. Any other points of discussion on this? Any other thoughts for our wordsmithing for items to include here? Ms. Curtis?
Yeah, to address Ms. Hudson's point, perhaps it would make sense to say the state bar should determine program fees based on among other things, if you want those. So it's clear that what we're really saying is the state bar determines these things, but these are the considerations, or that sets the fees, but these are considerations that they should be in the foreground based on among other things.
And I think I agree. Thank you, Ms. Curtis. And I think what I heard Mr. Weiner saying was that the state bar would set this in advance. So it wouldn't, to Ms. Hodgson and Ms. Curtis's point, it wouldn't be as the information is presented for a particular provider organization.
If you want to incorporate that, you could say should establish fees for certification of provider organizations, or establish a schedule of fees for provider organizations.
Based on, yeah.
So instead of, yeah, you got it, Miss Mealis.
Say it again. I'm sorry. Should establish
a schedule of fees for provider organizations.
The bar typically it's called considered a schedule of charges and deadlines, but it's the same concept. Should establish a schedule of fees
for certification of
And then I think you can just delete to determine program fees for. So we don't yet have a motion on this wordsmithed number 4. I don't know if folks want to continue discussing or if anybody is interested in making a motion.
I'll move it. This is Kelly.
I'll second.
Thank you, Mr. Kelly. Thank you, Mr. Kelly. And that was Mr. Welch, right?
Correct.
Any additional discussion at this time? Judge Pichon?
Yes. Angela, would you please call the roll?
Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Lincoln is absent. Dubois is absent. Ellis?
Yes.
Dr. Getz? Higuchi?
Yes.
Hodgson?
Yes.
Jones is absent. Kelly?
Yes.
Kopakin is absent. Cruz is absent. Lowe?
Yes.
Lucky?
Yes.
Halevsky?
Yes.
Robertson?
Yes.
Tuckman?
Yes.
Welch?
Yes.
Yamshan? Daniel Yamshan? Judge Pichon?
Yes.
Yes,
Motion
I'm sorry,
carries.
my microphone was off.
Thank you.
Thank you. I think we can now move to in our part 3 of 3, the other document that we've included as part of what I'm thinking of as the administrative aspects of provider organization certification. But in fact, as you can see, Ms. Mia Ellis has posted on the screen, this document addresses baseline eligibility / qualification requirements for provider organizations. As I previously mentioned, there's still, and we did have some robust discussion here today about the definition of affiliated practitioner. We do have a separate ethics standard addressing definitions that we haven't put up for vote for you yet. Here, another thing I'll draw to your attention is 3F, which is, I believe if you scroll down to the next page, there's a place where the subs group still owes you some suggestions on what should be included in 1 hour training of provider organization staff from State Bar ethical standards. And then I will also just quickly draw your attention to 3J, where as we previously voted, there was a discussion regarding 3J little I 2 and the phrase other than affiliated practitioners. Folks, I know everyone got this document yesterday, the same as the other. Does anyone have questions? Are there areas that you'd like to discuss further? If you're okay with it, I would like to take 1, 2, and 3F back to the subgroup and present it to you at our next working group meeting, along with our remaining provider ethics standards. But any other thoughts on other aspects of the document from the working group at large? Is anyone from the subgroup or otherwise, would anyone like to make a motion? Ms. Curtis.
Yeah, I noticed that number 4 deals with the same topic that we were just wordsmithing a minute ago.
Sorry,
Very
Ms.
last item.
Oh.
Very at the very, very bottom. Well, maybe I'm looking at the wrong document. I don't know.
This one, I believe
Program administration? No.
No.
Yeah.
Baseline eligibility.
Oh, okay. I'm sorry.
No problem. Would anyone like to make a motion, particularly on Mr. Kelly? You're muted.
Thank you. I am interested in the rationale for why you'd want an organization to have been in business for some particular length of time. I personally was thinking that 2 years was too short. Maybe other people would say you should be able to start one immediately. I'd love to hear the rationale for why got to be in business for 2 years before you can be certified as an organization.
Thank you, Mr. Kelly. Mr. Weiner?
Yes, Mr. Kelly, that's to your credit in part because you had raised at a previous meeting the question of whether somebody who has met the requirements for being certified as a practitioner could get together with another person who hasn't met those requirements and become certified as a provider organization. And so in discussing that, the subgroup thought that there should be some duration of time in business as a provider organization rather than just hanging the shingle and becoming certified.
Well, I think so too, and that only came up because somebody who had just finished my arbitration training was about to start an organization and provide arbitration services to the government with no background, no experience at all. So my question remains, why 2 years as opposed to none or 5 or something else?
Thank you, Mr. Kelly. I think in response to why 2 and not none, I think that goes to Mr. Weiner's comments. But why 2 and not 5? I think that as part of our conversations, did struggle with a balance between basically barriers to entry and those questions and requiring some amount to show experience in the field. Others want to weigh in on this?
Seems like a reasonable balance. We do want people to pay their registration fees.
Thank you, Mr. Pileski. And I'll mention it, I know we've mentioned this in the past. One thing that the California Business and Professions Code requires if you want to be a certified provider organization is that you must require your, and this is California based in brackets perhaps, but your practitioners to adhere to the ethics standards, both for mediators and arbitrators. So I think that that is something that we saw as another safeguard against Mr. Kelly's previously raised scenario of unsophisticated entities immediately seeking certification. Mr. Weiner?
Yeah, just another safeguard along the same line that the subgroup has recommended is that there be at least 2 practitioners and that the provider organization must have administered basically twice the number of cases that are required for a provider or for a practitioner to be certified. So there's, there are other ways in which some level of experience is a proposed requirement of the subgroup recommendation.
Great questions. Any other questions? Does anyone in the subgroup or honestly the working group at large have interest in making a motion for, with your permission, I would like to keep 1, 2, and 3F for further discussion by the subgroup, but if anyone wants to make an alternative motion, I'll leave it at that. If it's easier to go number by number, maybe I'll propose that as an alternative. Does anybody want to make a motion? Or, three is most of it. Mr. Kelly?
Well, you're the lead of the subgroup. If you think that it's worth having your subgroup refine these further and bring them back, I'd be against trying to adopt them now. There must be some good reasons why you want to bring it back to your group. You think it can be better.
I appreciate that. And I think in part for me, the definitions and the provider ethics standards are so intertwined still at this state that that is why I'm specifically interested in taking back items number 1, 2, and 3F. But I don't have the same feelings regarding the rest. So thank you. I will say, I guess before I offer an opportunity to make a motion again, given the vote that we had on the other document related to administration, I wonder if for 3JI2 and the language regarding other than affiliated practitioners, if anyone has any thoughts on that in terms of the consistency across the 2 documents. Mr. Kelly?
If you think it's appropriate, Madam Subgroup Lead, I'd like to make a motion that this language be conformed with what we already approved previously.
Thank you, Mr. Kelly. Any seconds?
Sure. I do.
Mr. Polewski? Any further discussion on this? Judge Pichon?
Ms. Janet Ellis, so you have a motion and a second. Is that just on item?
My understanding is that the motion is to adjust item 3JI2 to be consistent with what was voted on in the program administration. Sorry, Judge Pichon, to jump in.
That was my motion, yes, ma'am.
Okay. All right, that was a motion and a second. So I will ask Angela to call the roll. And that's just on, I'm sorry, go ahead.
Are you sure? Okay. Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Dinkin, absent. Dubois, absent. Ellis?
Abstain.
Dr. Getz? Higuchi?
Yes.
Hodgson?
Yes.
Jones? absent. Kelly.
Yes.
Kopaken is absent. Cruz is absent. Lowe.
No.
Lucky.
Yes.
Pileski.
Yes.
Robertson.
Yes.
Tuckman.
Yes.
Welch.
Yes.
Yamshan.
Yes.
Judge Bishon.
Yes.
The motion carries.
Thank you. Any other discussion regarding, say, everything except for everything in 3 except for 3J, 3F, my apologies, everything except for 3F? Is there any interest in making a motion regarding 3, excluding 3F? If there is none, then we can take it back and bring it to the subgroup for the next meeting. Judge Pichon.
I will move it. I'm not hearing that there's much discussion about those remaining issues, and if there's not, I think it would be good to get this out for public comment as is. So I think it's moved to approve all but 1, 2, and 3F,
Thank you, Mr. Tuckman.
including J2 as amended.
Thank you. Anyone want to second the motion?
Welch, second.
Thank you, Mr. Welch. Any discussion? Judge?
Ms. Ellis, could you just clarify exactly what we're voting on?
Absolutely.
1, 2, go ahead.
Sorry. So the vote is to submit for public comment number 3, except for 3F, or an alternative way of stating it is to submit for public comment everything in the baseline eligibility requirements except for 1, 2, and 3F, including with 3JI2 as previously amended.
Thank you. And there was a motion and a second. So Angela, would you please call the roll?
Armstrong is absent. Coulter.
Yes.
Curtis.
Yes.
Dinkin is absent. Dubois is absent. Ellis.
Yes.
Dr. Getz. Higuchi.
Yes.
Hodgson.
Yes.
Jones is absent. Kelly.
Yes.
Kopaken is absent. Cruz is absent. Lowe.
Abstain.
Judge Lucky.
Yes.
Pileski.
Yes.
Robertson.
Yes.
Tuckman.
Yes.
Welch.
Yes.
Yamshan.
Yes.
Judge Pishon.
Yes.
Motion carries.
Judge Pichon, I don't have anything further to present today.
Okay. Thank you. You've done a very fine job. And I'd like to thank you and your subgroup. And your subgroup members are Dario Higuchi, Katie Jones, Kimberly Lowe, Cliff Pileski, Eric Tuckman, and Christopher Welch. Thank you all so much. That was a lot of very intense work, and it's much appreciated. Also, I didn't thank Dr. Getz, his subgroup, so I'd like to mention them too. So it's Dr. Getz, Dana Curtis, Paul DeBow, Diana Cruz, Judge Lucky, and Daniel Yamshan. So thank you all for such great work. And we're on schedule. So as we've discussed before, item 2.3 is not for action or discussion, but had to appear because of the lateness between the last meeting and this one. I'm going to turn it over to Ms. Mia Ellis and Alan Weiner in case there are other remarks to be made before we adjourn.
Thank you, Judge Pichon. I don't have anything, just a reminder to the group. Our next scheduled meeting is February 10th. I do anticipate, though, in between sending out a poll so we can schedule future meetings for the post informal public comment periods. So we can come back after that for a review of what the public comments are.
Great.
Thank you.
And Mr. Weiner?
Just want to thank everyone, all of you, and particularly two subgroups who have been continuing to work, but also the administrative subgroup did a lot of work earlier on and their recommendations were adopted. So it's been a privilege to work with all of you.
And I just want to reiterate what I said at the very beginning. This is a spectacular work group. I appreciate all of the work that you've put into this and all of the time that you've put in. It is greatly appreciated and acknowledged. Thank you. I look forward to seeing you again at our next meeting in February. So I hope that you have a good evening and thanks for all of your work today. We are adjourned.
Thank you.
Thank you.